section is going to cover best practices.
Hi, thank you, Krista. I thought I handed out some materials on best practice and philosophical musings, if you will. But, you know, one thing I've learned on serving on the No Fault Standing Committee, I'm also currently on the ADR Ethics Board. And one thing I've learned about doing CLEs or serving on boards is I learn so much more detail, more information, more of the subtleties of the process than I ever would have if I hadn't. It's the fear of getting up and propounding statements about a topic, and you better know it, and that's how I find things out. And with the best practices, I thought it would be helpful. It is for me, but I thought it would be helpful to you, perhaps, to get the big picture, which is what happened to me when I got onto the standing committee. I knew there was a standing committee. I knew about the No Fault Act. I never put all of the moving parts together. And since I'm talking about best practices, I think it might be helpful. I mean, we start with the big picture. The No Fault Act was passed in the legislation, and included within the No Fault Act, of course, was the provision under 525 for arbitration, 65B 525 arbitration. So now we had a method designed to resolve disputes between the insureds and their insurers. So it was a system created purposely for that, and with the mandatory limit of the $10,000. So great, now we had some legislation, now we had a method prescribed by the statute as to how to resolve the disputes. And so when the No Fault Act was passed, there had to be a mechanism to oversee and administer it, and of course that was the No Fault Standing Committee. And the committee's job, number one, was to appoint an administrator with the approval of the Supreme Court. We do nothing without the approval of the Supreme Court on either board that I'm on. And that, in this case, happens to be the American Arbitration Association, so that they administer this on a day-to-day basis and oversee it. One of the other functions of the No Fault Standing Committee was to propound rules, the procedural rules. How does this get done? What are the steps? What are the procedures? And again, subject to the Supreme Court's approval, we propound the rules of procedure. And there can be violations of the rules of procedure, which could amount to a complaint. But also, the idea was to also propound the standards of conduct, similar to other standards of conduct for professionals, whether it's the lawyers board, the doctors board, whatever. And so we wanted in place a set of standards, and the standards weren't just for disciplinary purposes. They were really aimed at guiding the arbitrators, those of us who serve as arbitrators. It's kind of a roadmap and a guide for us as to what are the expected, at least minimum standards. And so with all the moving parts, then we have the arbitration process, the rules of procedure, and the standards of practice. And so now I'm going to talk about best practices. Well, how did we get to best practices? And what are best practices? What do we mean when we talk about best practices? And this has come up in my service on the ADR Ethics Board, too. There can be a violation of a rule. There can be a violation of one of the standards that could lead to discipline under the procedures that are set forth. But there is this gray area. From what we've heard this morning, I could think of a lot of things that you could tell an arbitrator what the best practice was. For example, it's a best practice not to be on the phone during the hearing. It's a best practice not to suggest that you've decided the case and need to hear nothing more about it. So, but all of it comes back to in the statute, in the procedural rules, and in the standards. And the overarching goal here is that the public have confidence, complete and utter confidence in the integrity of the dispute resolution process. And they're also designed to assist the arbitrator along the way. I mean, disciplinary rules, whether it's on the Board of Professional Responsibility or anywhere else, I think they've always made me nervous that I was going to do something wrong. And I always perceived it as almost an adversarial relationship. You have to follow these standards, and if you don't, you're going to be in trouble. And what I've learned is that these boards are really there as an aid to assist people. And I think that's what the best practices notion is about. We have had, on our board, we've had complaints on the standing committee and on the ADR board. Many times, once there has been a disciplinary proceeding, it's gone through its procedure, it can range from whatever the sanction might be to sometimes nothing more than a letter of best practice. And it's a letter to the arbitrator that says, you know, here was what the complaint was. We don't find that there was a specific violation, but we suggest that these are the best practices in those circumstances. And so that's what I mean by best practices, those which avoid not only a specific violation of a rule or the standards of conduct, but which go to achieving this overarching goal, that there will be a fair, impartial, neutral panel of arbitrators to ensure the integrity and fairness of the process. And that brings up the notion of avoiding even the appearance of impropriety. Now, my topic, I'm kind of throwing a little bit of a curveball for Chris to hear. I had intended to present them the three topics: best practices with regard to disclosures. What disclosures need the arbitrator make to the parties so that they can make an informed decision about your service? Now, we have biographical data that goes out to the parties. They can learn a little bit about you. We're supposed to put down what our practice, what percentage might be defense, what percentage might be plaintiff and so forth, or whether we really work in this area at all. We're not bankers and Hastings. And so, but the disclosure is important, and I'm going to save that for last. Because I have some scenarios, some questions that I'd like to throw out to the group here. And I like groups like this because there are people here who know so much more about the No Fault Act. I mean, Bob Hauer sitting here. If I have a question, I call up Bob. Let's say it's on page 19 or wherever it happens to be, about the No Fault Act and how it works, about arbitration and so forth. And so I like these because they are interactive, and I think it's a great exchange of ideas like we did with Angela's scenario. And so I'm going to do that with regard to the disclosures. With regard to the other two topics I wanted to talk about, and some of them we've covered at least briefly, and those were with regard to the best practices with regard to communications and with regard to conducting a hearing. So I'm going to start with communications. And I think the byword is, with regard to communications, is simply not to have any. Pretty straightforward. Rule 21, and I mentioned this earlier, so bear with me. There shall be no direct communication between the arbitrator and the parties other than at the hearing. Pretty straightforward. And of course, whoever writes these things always have to throw in a little curveball, unless otherwise advised by the arbitration organization. I don't ever remember being advised by the organization that it was okay to do it. It might be about a scheduling matter, perhaps, but that's about it.
Right. We also will let parties know that if you have an amendment, you can send that directly. That does fall into the AAA.
Right.
Advisory.
Right. And it says, so no communications or by agreement of the parties and the arbitrator. And to me, that's a little bit of a slippery slope to go down that. It may be that there's a communication, but to me, the best practice is to keep the AAA in the loop at all times, even about scheduling matters, particularly about scheduling matters, actually, since you need to know that.
scheduling matters are very important, especially one with the online scheduling system, so you're not getting booked for something that you can move around. But two, it's also very important for us to understand when the award is due, when the record closed, and when that award is due. You know, I've had a situation where the parties and the arbitrator moved the hearing, and they moved it forward instead of backwards. And one day, I got a frantic call from claimant's attorney saying, "You have the award. The award is due today." And I looked up in my system, and I said, "What are you talking about? The hearing hasn't even happened yet." Well, in fact, they all decided, without the AAA's knowledge, to move that hearing about a month ahead. And I said, okay. I said, I will do my best to get in contact with the arbitrator. The arbitrator was out of the country on vacation. I'd forgotten that that award was due. So I can't remember exactly what happened. I think we had to have the parties luckily agreed to an extension, but you know, it is our responsibility to make sure that award is timely, and we do very closely track it. And if we don't know when the hearing is happening, when the record is closing, we can't do that for the parties. We can't do that for the arbitrator.
Thank you, Krista. You'll find that a lot of these specific rules, although they're procedural rules, they do imply some commitment to follow the rules at the risk of a potential violation. But they also work in tandem, if you will, with the standards. And Standard 3 also addresses the issue of communication. And it states that the arbitrator shall avoid impropriety or even the appearance of impropriety in communicating with the parties. An arbitrator under Standard 3 shall not discuss a proceeding with any party or attorney in the absence of the other party, shall not have any direct communication other than what is prescribed in Rule 21, shall notify the arbitration organization of any attempt by a party or counsel to communicate directly with the arbitrator. So there you're going to be the hall monitor. Somebody calls you up, you have to report them to the principal. And whenever an arbitrator communicates in writing with one party, the arbitrator shall, at the same time, send a copy of the communication to every other party. And so there are some exceptions, but there are some strong admonitions. And a violation of a standard can lead to a complaint. And the complaint process is set forth in the materials under Standard 9, how that procedurally folds out, or unfolds, if you will, and also how the complaint process is handled. So to me, it's just so simple. At least in my practice, it's just not to have any communication whatsoever. To either direct them through AAA or by agreement of all the parties to send something to everyone along at the same time. So, I mean, best practices is like common sense. That way you can't violate a rule and so forth. Now, Walt, do you have a question?
Yes, post-award, so before the time expired or confirming or vacated, appropriate or not?
I don't think it's appropriate, particularly if there's the potential that there's going to be a motion. Oh, the question was, after the award, but while there is still time to bring a motion to the district court to vacate the award or seek some modification of the award, is it appropriate to contact or for the arbitrator to have contact with the parties? And I think that's a no-brainer. I would just say no, particularly if they're looking for support. And the rules also talk about the idea that the arbitrator should not be contacted for support or to feel out if there's going to be opposition to such a motion. Anybody else has any?
Any communication at that point still should be through the case manager, because the case, technically, even though the award was issued, is still there.
I'm curious, though, as to what the communication might be about.
Well, if you wanted some input from the arbitrator as to why he or she ruled the way he did.
And that's specifically prohibited. So to kind
There's
of
the ability to do a clarification request, where you can ask the arbitrator to clarify, and that there is specific procedures within the rules to do that. So.
And those are the type of administrative things like the addition, the multiplication is off, or whatever. I mean, those are pretty specific. But to get behind it, to find out what the reason for the decision was, particularly if you wanted to use it for one purpose or another in the district court, I think would be totally inappropriate for the arbitrator to bite on that one. So the other topic I was talking about was best practices at the hearing. We've heard a litany of things of what arbitrators should not do during the conduct of the hearing. So aside from the procedural order, the rules spells out the procedural order about opening statements, how the case will be processed, court reporters, giving of the oath, those types of things. But the arbitrator must conduct herself or himself in a way that is fair to the parties, and shall avoid conduct and statements which give the appearance of lack of partiality or impartiality. Arbitrators shall make all reasonable efforts to prevent delaying tactics, harassment of the parties or other participants, or other abuse or disruption. And that has to do with control of the process. A lot of my colleagues who've gone on the bench, my first question I ask them is, so how do you get up to speed on so many different areas of the law? I mean, maybe it's someone who practiced in personal injury or did tax work, and now you're sitting on the bench and you're hearing divorce matters, you're hearing maybe credit matters, all sorts of things. And a friend of mine said it's like sipping out of a fire hose. There's a lot to learn in a short period of time. You go to baby judge school and you get up to speed. But the one common theme that I kept hearing from all of them was learning to be in control responsibly, respectfully, and civilly of the courtroom. Huge, particularly with lots of things going on, for example, at arraignments and so forth. It can be a zoo. I usually end up at arraignments because it's somebody in my family's gotten a ticket or engaged in some other miscreant behavior. But every once in a while I go and I am amazed at what's going on. But control of the courtroom too, with the bully types, the strong personalities, the pounding on the table, those types of things. And I think that's kind of an insight into what it is for arbitrators. There is a way to do this. There is a way to accomplish it, I think, that can be done. And the judges I admire most are the types of judges who get acknowledgments, awards, or kudos, if you will, for being civil to all of the parties. And be tough, be firm. These are the rules. We're going to play by these rules. A little bit like parenting. You know, we have rules around here, and if you violate the rules, there'll be a consequence. But it's not personal to you, and it's not personal to anybody here. These are the rules we're going to play by. But you can also be respectful. Tom Gilligan, I was in front of Tom Gilligan in Ramsey County a couple of weeks ago on a motion, and he's got a sign out there. It says, "Nothing less than complete civility will be acceptable here." And I like that. I like the fact that judges, some judges, we all have war stories about some of the old codgers back in the day who were totally abusive to people and enjoyed it. And I don't know where that came from. I don't know. We could get a little Freudian, but but to me that is the essence as far as the conduct of a hearing, and making sure that at least the parties feel they've been heard, they've been respected. When I typically start out a hearing, I tell the parties, look, I've known both these lawyers for 40 years, 30 years, depending how long they've known me, and I'm familiar with them. You may sense a sense of familiarity with the lawyers, but I don't want you to take it the wrong way. This process is designed to be speedy, relatively so, to be expedited so that we're not having to call in witnesses. So the lawyers have sent materials. I've read them, or if I just got them this morning, I will read them. And that there's going to be a process unfolding. I want you to feel comfortable here, but it's going to be formal. I know how important this is to you. I know how important it is to the insurance company. And this is going to be the process. And I tell them what's going to happen. Lawyers may choose, if they desire, to make an opening statement. Then we're going to present evidence. The witnesses will be sworn before they do. And then I always ask the parties to sum up. Just the way I do it. Some lawyers will take a pass. Others, I said, no, I want to hear what you have to say. What do you think? And I explain this to the parties. At the end, here's what's going to happen. The defense goes first because your lawyer has the burden of proof. And then what's going to happen, the lawyer's going to tell me why they think the evidence should produce this particular result. And people seem to appreciate that. Now, to me, that's always been common sense. But once I got on the standing committee, I actually looked at these things and read them. I remember I served for a while on the JIG 4 committee. What are we on, JIG 5, 6? I don't know where we're at now. But I learned more about the substance of the law because I had to, being on that committee. It was a real education for me to really learn about this. And this is what's happened here for me. I've also learned a lot, too, when I've been involved as a decision maker on a panel with regard to a disciplinary matter. Trying to figure out where this went wrong. Is there a way to correct it? Is it fixable? What are the sanctions that ought to be imposed? And a lot of this seems like common sense, but it led me back to the basics, and that's reading the rules that I have here. Standard 4 is the gold standard, if you will, as far as the hearing itself. Arbitrator shall conduct the proceedings in an even-handed manner. Nothing new there. The arbitrator shall, these aren't suggestions, these aren't best practices, this is a shall. The arbitrator shall be patient and courteous to the party. Every one of us in this room has heard horror stories. We've experienced them, of the demeanor of some people and how they react with people. Very difficult to understand why that would occur. That would be a technical violation. And I think one of the things that came across today, there was a question by this gentleman about whether a complaint had been filed. And that's the process. If something goes haywire, that should be brought to us on the standing committee to look into it. And it's not only to help create this confidence in the process and to ensure that that's what the public's getting, but it could also be helpful to the arbitrator. Just as this, you cannot do this. And some people are blind, like a lot of us, self-included, to things that we do that we don't realize. And sometimes it takes some help. The arbitrator shall afford all the parties the right to be heard. That came up this morning about the closing argument. I've had arbitrators say to me, well, you can make an opening statement if you have an overwhelming desire. I mean, that's just a suggestion. The arbitrator shall allow each party a fair opportunity to present evidence and as well as argument. Again, makes sense. If a party fails to appear on due notice, the arbitrator may proceed with the arbitration when authorized to do so, but only after receiving assurance that the appropriate notice has been given and must comply with Rule 22. And then Rule 21, flip-flopping back and forth between the standards and the rules, Rule 21 says the order. Very simple. All of us who've tried a case in district court, same thing. Opening statements, closing statements, post-hearing conduct, and discussion and post-hearing conduct. Now, the main topic that I wanted to talk about, because it's always been interesting to me, is the issue of disclosure. To me, you know, with the arbitration selection process where you get your strikes and so forth. There's always a little bit of, Wile E. Coyote reaching into the Acme bag of tricks. Now, who am I going to, is this person going to be favorable to me? Is this defense lawyer? No, she's a plaintiff's lawyer. And if I do this one and I do that one, who am I going to end up with? But once the person, but then the arbitrator under oath has to make an initial disclosure. And the question is the extent of that disclosure. And to me, that's critical. Under the Civil Mediation Act, to borrow from another dispute resolution process, it is a petty misdemeanor if you don't disclose at least your background. And I just hand out my resume or my CV and they have at it. If you don't get selected, you don't get selected. I mean, the topic of raising the fee for arbitration has been a hot topic for a long time. Whether $300, covers the freight for the time that diligent arbitrators spend on this. If you read the materials, the hearings are usually pretty short, they're truncated, but for anyone who does this and takes it seriously, it's got to be a loss. It really does. But our view of this, and I don't mean to speak on behalf of the entire committee, but our view on it has always been, at least mine, let me say mine, as part of giving back, I think, to the process. It's not pro bono work, although sometimes it can seem like it approaches it. But there has to be an expedient method and a relatively inexpensive way for people to be able to do this. And that's part of the process, I think. On the other hand, the parties do need to know about potential connections. Now, the rule, the procedural rule, Rule 10, now I'm on the best practices disclosures if you're jumping around. Rule 10, I think all of us have a pretty good handle on what Rule 10 requires, and there are certain things that don't have to be disclosed. Okay, I'll speak louder. All right, Rule 10 specifies two circumstances for sure in which you don't need to make disclosure at all. However, you just shouldn't serve, in my opinion. Rule 10, two situations in which it is, not maybe, but is a direct financial conflict of interest if, within the last year, we all know this, the arbitrator, her or his firm has been hired by the respondent to the current proceedings or respondent's insureds for which the respondent provides coverage. Makes sense. Two, the appointed arbitrator has received referrals within the last year from named the chiropractic office or the neurological group, employees or agents of an entity whose bills are in dispute. And to me, this is just simple. Why bother with the rest of the process? You just don't serve. There's no need to serve. But now we get to the situation of, so what is, the rule is, if I go back to it, the standard 2 requires not only, the scope of the disclosure. The scope of the disclosure, how much beyond that is required. And this is where I have some scenarios that I'd like to discuss. And I'd like feedback too, if I'm dropping my voice again. So I'd like some feedback on it. But there are certain situations, because all of us, the longer we do this, we bump into each other in our practices in all sorts of different ways. Sometimes we're opposing counsel. Sometimes we've been co-counsel on a case. And we generally have relationships over the years, some more pleasant than others. So you get to the open paragraph. You've said, no, I haven't had any referrals in a year, and no, I haven't had any cases from the respondent. And so now you get to that open box. What else would be important? What may be information that would be helpful to the parties to decide whether this particular arbitrator should serve. And what are the nature of the relationships? And as long as we're at it too, standard 2 requires, as does the rule itself, requires that there's a continuing duty to make disclosure. So suppose something happens after you've been selected. Something comes up. Somebody wants you to serve as a mediator in a case, or someone wants you to serve as an expert witness for them. Should you do it in the first place? And if you do, should it require disclosure? So I'm going to toss some questions out here, some scenarios, and see what the group thinks. That's why I like this kind of format, because we get to discuss it and see what people think and add to it. But scenario number 1. The arbitrator has formally practiced with one of the lawyers who's appearing before the arbitrator. First general question, does that require disclosure?
Yeah, totally.
What if it was 30 years ago?
Yes. I still
Still?
should make the disclosure.
Okay, all right.
You can say you can be impartial, but you should make the disclosure. And you never liked the guy.
So that's the whole point. Here's the, you know, the Wile E. Coyote look. Well, I mean, maybe on. Number 2, arbitrator went to school with one of the parties or one of the lawyers and has remained an acquaintance, a friend, socially or professionally. Does that require disclosure? How about if I just went to school with someone at the parochial school on the east side of St. Paul or the south side of Chicago? Does that require disclosure?
Well, why wouldn't you disclose it? Yeah.
Why wouldn't you?
Yeah, I know the guy, I went to 6th grade with the guy. I hadn't seen him in 30 years.
Right.
Disclose it. There's no harm in disclosing it.
Right.
Why disclose it? Certainly.
That's why that's a best practice. So that's what I'm trying to make the distinction. Is it required? But on the best practice scale, I agree with you, 100%. There's no downside to it. You might be out to $300 and you go do something else.
On that same scale, do we have to disclose we're in the same Minnesota Association for Justice together?
That's the next one. MDLA and MNAJ. What about that? We belong to organizations.
Shouldn't that be on the resume or CV that you get? You already should have that information if you're doing your job.
Well, if you've done that, but suppose it isn't, and how much detail do you get into? I mean, there's always this tension, I have thought, within the arbitration system. You know, is this person plaintiff-oriented or is this person defense-oriented? And I do think that that's what the biographical information, I agree, it should be in there. But as an apt question is one of the questions I had. So should I make that disclosure? And so, okay, I'm a member of MDLA. How does that, if it's a disclosure, should it be up to the parties then? Now, bear in mind that at this point in the process, because, and this would be particularly true if it wasn't on your disclosure, you forgot to put it on your bio or whatever. Some people do and some don't. You're smiling. I'm just happy to be here.
I'm just enjoying the presentation.
Yeah.
You know, there are the occasional pro se claimants that I see. And I have a standard disclosure that I normally represent injured people and have claims against insurance companies, including the respondent in this proceeding. I can be fair and impartial. And I think that's important for those few but important parties that come through pro se, because they may not have what I just talked about, and that is the disclosure of the whole process, right, with pro se. So I do think that's important, and I put that on my disclosure every time. So at least they have that much.
Okay.
Jim,
I think you
Sure.
mentioned, you said you distribute your full resume.
Well, no, that's in my mediation practice under the Civil Mediation Act.
Oh, but not in
Yeah.
the trip.
No, I try to put as much as I possibly can in that resume, and it's supposed to be a much shorter version of that.
Yeah.
But that's required by statute at the penalty of a petty misdemeanor.
Yeah, I
Could be
conflated the two.
$300. A lot of money. I'd lose my whole fee. $300. So now, is there a question?
Isn't the best practices just to disclose any relationship you have with them? I mean, if Bob, Howard, and I are in a square dancing group together, I gotta disclose it. How long ago the next square dancing group, and that's all I can do is a square. Yeah. He's just in a square dancing group 3 months later, he's gonna wonder why the heck he didn't know that.
What might be embarrassing to Bob? For that to get out.
Beyond that.
But again, what we're talking about is what's required and what are best practices, and do people have some discretion as to what they choose to disclose or what they choose not to disclose. So the arbitrator has had or has pending several cases adverse to the parties or one of counsel or the respondent, insurer. No, I've got 25 cases against the insureds of or against the company itself, and fill in the name of the company where I'm plaintiff's counsel. Is that required? I mean, technically under the rule it doesn't say that. I'm not getting any business, and there's no strong connections. But after all, I'm a member of a group that represents principally injured persons. So
I think if you're actively, yeah.
I say have pending claims against State Farm or Allstate, whoever's the respondent, and I can be fair and impartial. If
Yep.
they don't think I can't be, then they should bring, object.
All right. How about if the arbitrator has served as a mediator many, many times for one side or the other? Now, most mediators are reluctant to do arbitration because if you call the ball a ball or a strike, somebody's not happy. Typically, I don't know what it is. I mean, we are professionals, and you see two prize fighters. If it's a clean fight, there's a hard-won respect at the end of the fight and admiration to some extent. But if it's not a clean fight, that's a different story. But we do this as advocates, too. We go up against each other. We try our best to knock the other person out and win the prize. And so for people doing mediation, it's kind of a touchy area to do arbitrations. But if you're going to do it, you have to call it a ball or a strike. Somebody you've known for 30 years, sorry, you go home with nothing, zero. Tough. Don't mean it in that way that it's tough, but that's just the way I saw it. So here, now a person is a mediator. It's a big part of her practice or his practice. That's what they do for a living. Is the other party, are both sides, the other party obviously entitled to know that you get selected by the respondent or lawyers working for the respondent many, many times a year. Do 20 or 30 or 40 mediations a year for them. Is that required?
Anything that creates the possibility of potential bias should be disclosed. If it doesn't pass the smell test, disclose.
If you have to
Err on
think
the
about
side
it
of
for more than like 3 seconds, it should be disclosed.
Right.
Even if it makes you pause, put it down.
Yeah. Err on the side of disclosure.
You stole a line from my materials here. It was kind of after Johnny Cochran.
Oh.
If in doubt, get it out.
The glove don't fit.
That's right. Again, best practices. How about if the arbitrator has, in the distant past, I mentioned this to Angela today, served as an expert witness for one of the lawyers in a case?
Absolutely.
Absolutely. Arbitrator serves on professional committees or boards with counsel for one of the parties. This has come up where I have said, well, she and I sit on the no-fault standing committee or on the ADR ethics board. Right? Okay. Arbitrator's a member, and this is not a square dance group, but of a church board with counsel for one of the parties.
Lutherans or Catholics?
I would say
To me, these are all things that have come up for me, and I just always make the disclosure. Sometimes it gets a little long because you've been doing this so long that you're going to have these types of relationships over the years. But to me, I see absolutely no downside to it. There can't be even the appearance that you didn't disclose something that you should have.
I think it's also important to remember that it's an ongoing requirement to disclose, whether that's the morning of the hearing, or we've even had situations where an arbitrator has stopped a hearing and said, you know what, I need to step out, and has contacted the case administrator and said, you know, in the course of this hearing, I've realized that I have some relationship to, you know, a provider or whatever it is. So, I mean, it's ongoing. Even after the fact, we've also had situations where somebody is reviewing the materials and getting it forward, and they come across something within, you know, the reading, and they contact the case administrator and said, hey, I didn't catch this until now.
Is there something that needs to go through the AAA? Because I've had sort of the same scenario where a client of mine started treating at a different facility post-filing. Those bills obviously never went to the arbitrator. We show up at the hearing, and there it is in the book, and the arbitrator says to defense counsel, hey, in full disclosure, I've received, you know, referrals from this particular provider. I did not know they were involved in it until just now. Is that something the arbitrator should have gone to AAA with, or you just talk to defense counsel about who you've known for 30 years, and defense counsel does not trust that you're fine, go ahead. But is that something that should go to AAA, or is it fair just to discuss it once apart?
It's probably encouraged to go through the AAA, because you might be sitting in the room, if you have the arbitrator saying, hey, I'm telling you I have this additional disclosure, you kind of put the parties in a position to say it's okay. And the arbitrator may know, you know, one side pretty well, then you put the other side who's maybe not as familiar with the arbitrator into the situation where they feel like, I don't want to object to this person right in front of their face. You know, so I think one thing the arbitrator could say, I need to make a supplemental disclosure. Here's the situation. I'll step out, you know, and perhaps you can call the case administrator, or you guys can talk about it together. And we always have concern when an arbitrator is essentially being made aware of that there is an objection, or you have to one of the parties in a situation where they need to outwardly object to the arbitrator. I would say a best practice would be to get the case administrator involved, and that person can kind of triage. So that answers your question.
Right, and just drawing an analogy under the Federal Arbitration Act, that sort of scenario, absolutely mandatory. Either the parties agree and stipulate to the service, continuing service of the arbitrator, or the arbitrator has to back away. And there's no give or take. You know, if you're selected an arbitrator in a different subject area on a no fault, in a private arbitration, and anything else. I mean, that sort of jurisdictional background and boundary is what serves you to make that determination and call if you're selected as an arbitrator. So by all means, any entity, you know, in this context, it's case manager, American Arbitration Association, and it might be in the construction context or what have you. To the extent there's a case manager involved, it should absolutely be reported to the case manager immediately, and then, you know, then the determination has to be made. If there's an objection, then it's easy. The arbitrator can say, okay, I can't serve anymore.
Yeah, we typically, like I said, we typically don't like the arbitrator to know that there's an objection, and we operate that process, whether it's from, you know, day one when we get the oath to at the hearing. Essentially how that would be handled is if the parties didn't agree to let this arbitrator serve based on disclosure, you know, the AAA would make the call. We make that first initial call. And so we may decide, you know what, this arbitrator is we're going to reaffirm this arbitrator, they're going to continue the service. That arbitrator's out of the room, they have no idea that all these things happen. right? So they're under the impression both parties are cool, both parties are okay with it. You know, we try to avoid that appearance of there was an objection, there's one party who was opposing the arbitrator, so that thereafter, you know, there wasn't an argument, well, the arbitrator voted, you know, went against me because he or she knew that I didn't want them on the case. So we try to take that argument away.
Even in that scenario, remember, just because you're selected doesn't mean you have to serve. At any point in time, the arbitrator can withdraw from serving as the arbitrator, even in the point of reaffirmation. If it's completely uncomfortable for that arbitrator to issue that particular ruling, the arbitrator could say, no, I'm not going to do it. But that rarely happens, but, you know.
May I add to a list of hypotheticals? I have a question that's been nagging me.
Sure.
Is it a conflict if someone serves as either active representative counsel for a particular insurance company, or if they're in-house with that insurance company, to serve as an arbitrator when that insurance company is the liability carrier, not the no-fault carrier, but the liability carrier associated with that same crash? The particular situation I had was I walked into a bit of a buzzsaw arbitration where I knew I was getting to zero, I got to zero the moment I walked out, and then when it came time to negotiate the liability case, the adjuster said, well, the arbitrator didn't find much weight to your case, so we're not offering anything off the litigation. It was resolved by way of litigation, but it was an inherent conflict by the time that the liability adjuster said, well, this guy said your case was worth nothing, so we're not offering. Now, it's not really a financial conflict at the time of the no-fault chain. You could even argue that it's a financial advantage for them to award the benefits that you're going to offset to the liability case, unless you get to zero, and then you have them using that zero as the scripture on why this case is never going to settle.
You also have a potential Unfair Claims Practices Act violation.
Right.
Yeah.
So that poses a dilemma.
I was trying to get her to put it in writing.
I think that arbitrator did you a favor,
Yeah.
you know, because you're not going to, even if they compromise your no fault, with a zero, what kind of offer of judgment can the defense lawyer make to you when you've got medical bills, that at least some or all of them, a jury's going to give the plaintiff?
Yeah.
So good luck to you. What's your offer of judgment?
Yeah, I mean,
$8,000 in bills, what are you going to offer? I mean, they did you a favor.
Right. I guess the only problem is it's built in about an extra year's worth of litigation and the $5,000 of expenses associated with that litigation. It probably would have just settled on your kind of standard run-of-the-mill case had it not been for that scenario. So I don't know if that's something that we should be objecting to AAA if that's the situation.
I know that there was an appeal similar to that, and the committee did make a decision. And if I recall, it really hinged on whether or not there was something pending or not. I think, if I recall correctly, in that scenario, they can move into the liability. We haven't filed anything yet, or we haven't done anything, but they're the liability, you know. So the committee did come down and say, no, we're going to reaffirm the arbitrator in that, under that particular set of.
File a lawsuit.
That's my recollection of what.
Yeah.
Interesting.
Well,
Question on disclosure, what if you or a member of your family has treated with one of the providers whose bills are in dispute? I'm not talking about individual doctors, I'm talking about big groups from orthopedics, Minneapolis, neurology. Should you or make that disclosure? Are you required to make that disclosure, number one? Number two, if the answer is yes, how much do you disclose about your treatment or the treatment of your family?
the question is if the arbitrator has, or a member of his or her family has treated with the group whose bills are in controversy. The first question is a disclosure required? And if so, the extent of the disclosure. And I would opt for making the disclosure, but beyond that, I don't think much more information without violating either my right to my medical privilege or that of my family. But and that, I don't think it's required, but as a best practice, I would think I would do it. I mean, it's a no-brainer if it's the same physician, the same surgeon who did the plaintiff's shoulder that did mine or whatever. But if it's her partner or something else, I just don't think you can go wrong.
How far does that need to go? We see lots of plaintiffs who get therapy, physical therapy at
Right.
Mr. Kenny, which is part of the Abbott situation. My daughter was born there. I've had at least one, maybe two surgeries there. I mean, it
Yeah.
go on forever. I mean,
It could, but I think it's a question about how recent,
Yeah.
similar nature of the injury. But boy, if I'm a patient of the clinic, and again, it may be like I never liked him in the first place. It could be a bonus for the other side, but I don't know. To me, it's just so simple. It's a line. In the past, I or members of my family have treated there.
But then you get into health partners, you know, you have, you basically end up saying, yes, my family has treated with a doctor sometime, somewhere.
Yeah.
You know, I mean,
It doesn't hurt to disclose it.
It's just how long this disclosure is going to be.
right, I mean,
For people, especially my age.
I know in your circumstances, when we receive an objection, we're looking at, you know, the intentions of the parties. We look at it, you know, is it substantial? Is it ongoing? How recent was it? So if you had a surgery there 20 years ago, 10 years ago, you know, that's not something we would move an arbitrator for. So it is a bit of a judgment call, but, you know, those are the things that we look at when we get an objection.
And a different question that I think is a little more back in the mainstream, and you may have addressed this about disclosing, let's say the lawyer, the petitioner's lawyer is from a large law firm in the IDF Center called Schwabel, I guess, whatever, Stephen. As an arbitrator, and I have, you know, like anybody in this room who's done defense work, has had numerous cases and tried cases against them for years. Yeah, I suppose that's something I should disclose, you know, so that although the defense lawyer on the specific no-fault knows that about me anyway, but you know, I suppose that's something that should be out there.
I mean, I keep coming back to why not, you know.
They always strike me, I think, because anyway, so I've never had one. Yeah.
So we have time left for an open discussion, or I'm going to move on to the...
Yep, you've got about 5 minutes left.
5 minutes? Okay. Usual for me at this time. When you pull these together, I think following the best practices, it's kind of following your own moral guide as to, and I always ask myself, what would I want to know? Would I want to know this if I were one of the parties? Would it be important to me? And that's probably as simple as it gets. A lot of the information I already possess because, like I say, I've been doing this so long. But if there is a violation, then you make a complaint, and the rules for the complaint process are set out in Standard 9 and how it works and so forth. But what are the impact of a violation of the rules or any of the standards? And it runs the gamut. It could be removal from the panel with set conditions for reinstatement. You have to do this. We see parallels to this with the Board of Professional Responsibility. And should the committee determine that removal is appropriate, such a recommendation will be made to the Supreme Court, so that there is a second tier of oversight. It could be a suspension for a period of time. It could be the issuance of a public reprimand. And that will be posted on the organization's website, which shall include publishing the arbitrator's name, summary of the violation, and any sanctions imposed. And the public reprimand may be published elsewhere. This is something that has come up with the ADR Ethics Board too, is does this affect your licensure as a lawyer? On the ADR Board, our oversight of alternative dispute resolution includes people doing family law, things I had never heard of before I got on the board. I thought a PC was a computer, and I found out a PC is a parenting consultant. I found out what a parenting consultant is, or a PTE, Parenting Time Expediter. And so in that arena, it can affect, some of these people are licensed psychologists, some of these people are licensed social workers and so forth. So that public reprimand could have repercussions further than just whether you're going to sit as an arbitrator or a mediator or someone else doing another flavor of ADR. Do you have like a meter over there? And then there's the issuance of a private reprimand, which is self-explanatory. And then number 5, the provision of a best practices information. And this truly is what best practices are about. Someone has a blind spot, you bring it to their attention, and you hope that it's corrected for the benefit of creating the public confidence in the system. Could impose training requirements, supervision of the arbitrator service on the panel by a designee of the committee, and ultimately the notification of any professional licensing authority with which the arbitrator is affiliated, and notify them of the complaint and its disposition. And the, as I say, the procedural rules for the complaint process are set forth there. So there is some notion of due process, that you have a right to be heard, appear, and make your case as best you choose. So.
All right, are there any questions in the room? All right, Cindy, are there any questions via chat?
We received one question, and the question is, do you disclose if you are personally insured by the respondent insurer?
I am.
Why not?
Yeah, I do. Again, it comes into that rubric. Why not? You know, rather than ask why.
Especially if it's a mutual company, you want to make sure you get your refund check.
That's right. That's right. Or if you're a stockholder, you know.
All right, so that wraps up our second seminar here. We will take another 10-minute break.